Hello, welcome back. Uh, we hopefully have a good one today. So, in the never-ending saga of Castro versus Abrams et al., uh, we've had a bit of a flurry of activity today, and after yesterday, I have a feeling this one's going to be a bit of a letdown, at least as far as quality goes, because yesterday I I highly praised the writing of Mr. What's his name? Gorman, Matthew Gorman, Google's Boston-based attorney, and his writing was just spectacular. And I was slightly less explicit in my praise of his writing than Merb was, but frankly, we both found it phenomenal. Uh, if less entertaining than some we've had. Today, yeah, we're back to a toddler scribbling in crayon, I think. And that should be more entertaining, but I'm going to need more Advil because of it. So with that, let's jump into it. As usual, we'll start with the docket. So yesterday, we read the motion for extension of time to file an answer by defendant Google until after the third amended complaint, which made sense. And I said there's no way, at least no way I could think of, that this wouldn't be granted. Merb guaranteed it would be granted. It was granted. Docket number 106, electronic or Judge Allison D. Burroughs, electronic order entered granting 105 defendant Google LLC's motion for extension of time to respond to plaintiff's forthcoming third amended complaint. Bing, bang, boom, done. Not surprising at all. And Delete Lawz, having to always have the last word, comes back after the order was granted with his first response to motion 105 for extension of time. So when that was the only thing he had filed today, I got to thinking about it, because I've noticed, this is his first response. That would indicate he expects a second response, maybe even a third response. But let's look at Google's motion from yesterday. It's not first motion, it's motion for this. But then we go back up. Number 103 from Delete Lawz, second motion for contempt. First motion for leave to file a second amended complaint. First memorandum in opposition. But then we see Benjamin Wish, opposition to the motion. So it's almost like the attorneys have the expectation, I'll do it once and I'll do it right. Delete Lawz, well, when you scribble in crayon, you do it multiple times, apparently, because before the end of the day, we had first motion to correct 107 response to motion opposition for time extension. So, yeah, that And I haven't read either of them. I just glanced at specific parts. It looks like they're mostly the same. So I'll react to 107 and then try to speed read through 108, see if I spot any differences, basically. But this was wholly unnecessary, and I have a feeling it's just garbage. But let's jump into it. So this is document 107, opposition to defendant YouTube, Google LLC's motion for extension of time to answer. So the header, opposition to defendant YouTube's motion for extension of time and in support of motion to clarify. Right. Plaintiff Jose de Castro offers the following response to defendant YouTube's motion for extension of time to respond to plaintiff's forthcoming third amended complaint. In support of this response, plaintiff submits a memorandum of law, which is fully incorporated herein. A. Extension of time. I don't know why he used a lowercase a there, and I mean, I would have used a 1 anyway, but that's me being picky. So, plaintiff opposes an extension of time for YouTube to receive an extension of time until 30 days after a third amended complaint, especially since no third amended complaint is currently planned and it would delay this action indefinitely. Let's see. I mean, YouTube did say purported third amended complaint because he's used, well, him and the court, they've used amended complaint and supplemental complaint somewhat interchangeably, and so YouTube did say purported third amended complaint. We're treating it as a third amended complaint, but let's look. So we have the complaint, docket number 1. Down. Well, I know the approximate date. So we have an amended complaint filed 16th of November. So that's the first amended complaint. That's the one that switched from defamation to copyright. But then we have the supplemental complaint, but this was treated as a second amended complaint because it tried to allege causes of action against YouTube. And he filed for leave to supplement the complaint, ECF 76. Judge Burroughs granted plaintiff's motion to file a second amended complaint. So, but then he filed it as a supplemental complaint. So, what is it? According to the judge, it's a second amended complaint. And then we scroll down, and he's asked the court once again, can I file another supplemental complaint? And the judge granted leave to file a second amended complaint. But that would be the third amended complaint. So can you see why Google's confused? What the hell's going on? What is it? I don't know. And even if it's a supplemental complaint, just file it. Just file it. You've been granted permission. File it and let Google respond to everything all at once. But no, we're in Delete Lawz world, and we've got to play by his rules, apparently. So, continuing, although counsel for YouTube did call me on the phone, it was at my request to discuss how YouTube could do better with their DMCA and anti-bullying policies. I did not realize we were conferring to minimize motion practice, but parties were unable to find common ground nonetheless. The call was recorded. Did you have permission to record? Plaintiff did not agree to an extension of time to answer. No. You mean when Mr. Gorman said plaintiff didn't agree, so we're asking the court for an extension, which the court then granted. Imagine that. Plaintiff also saw no reason that YouTube would need more than 60 days, and none was mentioned by YouTube's counsel. Well, once again, you may not see why they need more than 60 days, but unlike Delete Lawz, who rushes out and responds the very next day to a motion, and then files a fixed response because he got it wrong. YouTube's lawyers, YouTube's very highly paid lawyers, realize I'm paid to do this once and do it right. So, as I mentioned yesterday, Mr. Gorman is a Boston-based of counsel. So I have no idea what he's paid. The other attorney who filed the waiver of service, can't remember his name at the moment, and I don't want to click through. So he's a New York City-based seventh-year associate. Seventh-year associates at this firm are paid a base salary of $400,000 a year. And probably, this varies year by year, and I didn't see what last year's bonus was because, they're granted in December. But most years you can expect him to receive about $100,000 bonus. So you figure he's based on 2,000 billable hours, which he may bill 3,000 hours. I don't know, but the expectation is in the area of 2,000 billable hours. So he's paid about $250 an hour, which means the firm bills him at $500 or $600 or even $750, per hour. that means the expectation from the firm is don't mess around. Get it done, and get it done right the first time. Especially, I don't know the contract between the firm and YouTube. Merb speculated, and this very well could be the case, that they don't bill Google hourly. They have a fixed contract where they get paid so many millions of dollars a year to be the outside counsel, period. And that's the firm, not just these specific lawyers. So if that's the case, the firm isn't trying to pad its earnings by billing extra hours. In fact, they want it done now. They will do it fast. So if they need more than 60 days to do it once, yeah, it makes sense. And they may not have mentioned it to Delete Lawz in the phone call. They didn't have to. They gave 4 reasons why they were asking for more time in the motion. Every one of those reasons by itself made sense. Cumulatively, it more than made sense. So, continuing though, YouTube's counsel also didn't mention that he would be responding to a 3rd amended complaint and his novel interpretation of the motion practice in this action. Instead, YouTube's counsel refused to assist me with getting my DMCA subpoenas processed or to get my DMCA notices properly looked at, but expected me still to stipulate to giving them more than the already 60 days that they had to answer. I wasn't frozen there. That was me speechless. He thinks it's YouTube's counsel's job to serve subpoenas for him. No. You're suing YouTube. It's not their job to help you with anything. Are you insane? Oh. And then in bold, I definitely did not state an intention to wait to file a 3rd amended complaint until after YouTube responded to my 2nd amended complaint. Well, you've already asked and been granted permission to file either a supplemental or amended complaint, depending on who you ask. And we've seen your emails with Benjamin Wish. It's very believable that you did, in fact, tell them exactly that. But, in fact, that would have brought to the surface YouTube's novel view of the motions in this action, and I would have cleared up their mistaken interpretation, or at least argued mine. I certainly do not need YouTube's response before supplementing the complaint with additional events that have occurred since the FCS first supplemental complaint, which it is irrelevant. Nor do I wish to wait 60 days to do so, although I was surprised that the leave to file a 2nd supplemental complaint did not include a due date. I will be working on the 2nd supplemental complaint this week. Okay. Plaintiff's upcoming 2nd supplemental complaint will not include any additional legal arguments, but only additional facts that make up additional copyright claims since plaintiff's 1st supplemental complaint at ECF number 79. Plaintiff already has 60 days to answer or otherwise respond, but instead wishes to completely skip this in lieu of answering a potential upcoming amended complaint. There is no amended complaint coming. Well, like I said, even if there isn't, get your supplemental complaint in and let them respond to all of the allegations at once. Why is that difficult? Is it because you want to cost Google more money? I believe it is. And this is asinine. Like, plaintiff's upcoming second supplemental complaint will not include any additional legal arguments, just facts about additional copyright claims. Then in that case, maybe Google should just go ahead 12b6 this, because as was mentioned in yesterday's motion, the motion for an extension, Google doesn't know what it's even defending because there are no causes of action alleged against Google in anything. So the reality is they're asking this partly for Delete Lawz benefit because they said, we don't know what we're defending. So yeah, I mean, we can 12b6 this. We can say, once again, 12b6 is a motion to dismiss because for failure to state a claim, a cause of action upon which relief can be granted. Well, if not a single cause of action has been alleged against Google and there's not a prayer for relief against Google, it's an easy 12b6. So does he want them to 12b6 and then him defend it saying no, this isn't the case, and even if it is, then let me amend, and Well, wouldn't it be easier to just get it all in right now? I think it would be. But note the current catch-22. I cannot respond to a DMCA counter notice for this latest infringing video mentioned in ECF number 97 until I file the second supplemental complaint containing that video. Therefore, YouTube cannot lose safe harbor protection for any videos in the second supplemental complaint until after the second supplemental complaint is filed. And then they also fail to act on the DMCA takedown notice for those videos. Well, that is not a catch-22. That's just complete nonsense. Here's why. So, for starters, the video in question is Kate's video from 3 weeks ago, where she's making fun of the video of him from 7 years ago, where he doesn't know how to use a hammer. That video, I checked right before I went live, is still on the Masshole channel. It's still live. So either he hasn't copyright claimed it, or he's such a frivolous abuser of the copyright claim system that YouTube reviewed it and realized, hey, this is obviously fair use, and ended it right there. YouTube can do that. That's within the safe harbor. This isn't hard. He still does not know how the DMCA works. he still does not understand fair use. Because remember, DMCA is protections for YouTube. Fair use is protections for Kate. So I mean, he says he can't respond to DMCA counter notice. Why can't he? And here's the thing. So once again, the DMCA, you give notice, which is the copyright claim. That gives the supposed infringing party, in this case, Kate, so many days to file, to either take down the video or file a counter strike, counter notification, and say, but fair use. And then YouTube says, all right, put up or shut up, bring a lawsuit. So his response to the DMCA counter notice would be filing the second supplemental complaint. So once again, this all has to happen before Google can respond to that, and Google doesn't have to respond to his previous allegations in order to respond to this allegation. There's no catch-22. He just doesn't understand how any of this works, no matter how many times it's been explained to him. And I've got news for you, Sunshine. Google's not losing its safe harbor protection on this. I mean, I don't care how many times Dr. Law tells you that the DMCA and fair use are unsettled law. There's so many cases out there. It's settled. It's etched in stone. You're not getting this overturned in the court. It'll take an act of Congress. Maybe that's what he should do. He keeps saying he's going to have executive power, but copyright is federal law. A governor's not going to have any impact whatsoever on copyright law. Frankly, he's got a better shot at the House, not the Senate, but the House, because due to gerrymandering and stuff, you can get crazies in there. But Section B, clarification of supplemental complaint. Plaintiff can see how YouTube might interpret the docket in the light most favorable to making plaintiff's FSC an amended complaint that would clearly be defective. However, this is an unreasonable interpretation. Except the court has called it an amended complaint. There's contradictions. But one, at all times did plaintiff request permission to file a supplemental complaint pursuant to Federal Rule of Civil Procedure 15D. But the court granted permission to file an amended complaint. So in that case, you didn't have permission to file the supplemental complaint anyway, so it's defective. See how we can twist this? 2, plaintiff made it clear in his request for leave to file that the supplemental complaint included events that occurred after the first amended complaint. 3, the plaintiff had no way of knowing that the events in the supplemental complaint would occur at the time of the filing of the principal complaint. 4, plaintiff did not plead in the alternate for amendment if the supplement was not approved. And 5, plaintiff titled the motions for leave to file and supplemental complaint appropriately. But once again, The court did not grant leave to file any supplemental complaint, the first or the second. It granted leave to file an amended complaint. So if you're going to get pedantic on this issue, then the defendants can come back and say, hey, look, Buster, the court gave you permission to file amended complaints. Therefore, these supplemental complaints are defective and should be dismissed out of hand. But I agree. There's confusion. You can see why Google is confused. The docket is inconsistent. It is plaintiff's understanding that this court's orders granting leave to file the plaintiff's supplemental complaints, ECF numbers 77 and 102, simply used the terminology consistent with Massachusetts District Court, which is to amend by filing a supplemental complaint. However, this court has a habit of misnaming things in its orders. ECF number 80. Let's see what ECF number 80 is. Second motion to correct record by Jose Maria de Castro. What, because that's like his fifth motion to correct the record? But this court has also made it clear that the facts are more important than the naming of them. If the court was only allowing new claims to be added through an amendment to the complaint, plaintiff reminds the court of its rights to file supplemental complaints in lieu of amending the original complaint each time, especially given the way that plaintiff's first amended complaint was handled. Plaintiff's intention is to avoid... Wait. Especially given the way that plaintiff's first amended complaint was handled. How? I mean, seriously, how? He asked for leave to file, or, well, no, he didn't ask for leave, because First Amendment is by right, so he filed it. Is the complaint about the untimely notice of dismissals that were filed roughly contemporaneously with the first amended complaint? Is it... I'm confused. I'm confused. I mean, Delete Lawz is not a logical person. But this is a step too far even for me. I don't know what he's getting at. But he continues, plaintiff's intention is to avoid further amending the complaint when it is not necessary to do so. Unfortunately, because of YouTube's actions after the principal complaint in this action, making it liable for a portion of the damages, I don't see how I could avoid adding them as a defendant, and the other defendants seem to have stipulated to YouTube being added for the same reason. Did they? I mean, he says defendants seem to have stipulated. That's... unless this was discussed in a live hearing, this is a conclusory statement with no evidentiary support. Not that it matters, but this isn't Josh and Kate agreeing because they think, oh, well, we can have Google pay some of the damages when we inevitably lose. No, it's because they realize that letting an 800-pound gorilla in to smash him around a little bit can only help them. But also, they realize, as frivolous as the case against them is, the case against Google is even more so, because Google, from what we've seen, has followed the DMCA safe harbor guidelines. They have their notice and counter notice system up and running and have followed it. So it just, Google pleading that they followed it and didn't see it, and determined that Kate and Josh were within the fair use guidelines, that just helps them. Does he not get that? Although YouTube's counsel continues to ask me to move my claims against YouTube separately to California, I don't see how two juries would be expected to determine proportion of liability. However, I would not oppose YouTube's moving of this action to California federal court, especially since we're still pre-discovery. Once again, that's conclusory. Where do we have it that YouTube has asked to move this to California? And to determine proportion of liability, well, number one, he hasn't asked for anything. Remember, there is no prayer for relief or cause of action alleged against YouTube. None. But there's, in any prayer for relief, he's not asking for joint and several liabilities. I mean, there are common facts, but if YouTube were found liable, which they won't be, neither will Josh or Kate, but if hell froze over and they were, there would be separate awards. He doesn't seem to understand this. But points and authorities, I still don't understand why he does this. You need to put your legal argument. Courts may permit supplemental pleadings, setting out any transaction, occurrence, or event that happened after the date of pleading to be supplemented. Hang on. I think this is a copy and paste from his motion, his request for the supplemental pleading. So why is it here? Seriously, why is he arguing the merits of granting a supplemental complaint in his opposition to the extension of time to respond? They're two separate issues. I mean, seriously, what does this have anything to do? Because seriously, let's read this whole section with no interruptions, and you tell me, does it belong here? Courts may permit supplemental pleadings, setting out any transaction, occurrence, or event that happened after the date of the pleading to be supplemented. Civil Procedure Rule 15D. The First Circuit has recognized that courts customarily have treated requests to supplement under Rule 15D liberally. U.S. ex rel. Gadbois v. For America Corp. This liberality is reminiscent of the way in which courts have treated requests to amend under Rule 15A's leave freely given standard from the same case. See also Keith v. Volpe from the Ninth Circuit. Rule 15D is intended to give district courts broad discretion in allowing supplemental pleadings as a tool of judicial economy and convenience, and its use is therefore favored. No factors exist that would support denial of plaintiff's motion. See For America Corp. Listing some factors a court may consider in denying a motion to supplement. Although federal courts have found that a liberal interpretation of facts to define claims is appropriate for pro se litigants, their procedural actions should be taken literally. Still, pro se documents should be construed in the way most reasonably intended by the pro se party, which would typically be in the pro se party's interest, or minimally in a literal way. Haynes v. Kerner. So once again, why was that entire section there? It has nothing to do with whether or not the court should grant the already granted extension. Conclusion. Plaintiff prays, not plaintiff plays, that the court will clarify its supplemental complaint as being a supplemental complaint, since it is that and the facts show it. Plaintiff prays that YouTube be required to show just cause why it should be allowed to delay in answering the complaint against it before plaintiff is required to prove that it would be prejudicial. But once again, it is prejudicial if instead of responding to one thing, well, let's put it this way. Let's say if Google has its way, it responds to two things once. If Delete Lawz has his way, Google responds to one thing once and then another thing once, meaning they have to respond twice. Two responses is more prejudicial than one response. Besides which, everything else pretty much goes on hold until they respond to the supplement anyway. So it's a matter of not just Mr. Gorman's efficiency, Google's efficiency, it's efficiency for the court. I mean, federal courts are overworked. Look at how many courts need to be filled. Look at how many judicial positions need to be filled. There's a backlog in the courts. And if the judge can respond to one motion instead of two, it benefits the court. But once again, this supplement is not contingent on Google's response to the previous complaint. If it's a separate issue, it's a separate issue. So plead it and Google can respond to everything in an omnibus answer or motion to dismiss or whatever. Once again, the only reason I see for him doing this is he wants to cost them more money. But let's race through the amended, the fixed opposition. So plaintiff offers the following response, blah, blah, blah. In support of this response, memorandum of law incorporated. Extension of time. Plaintiff opposes an extension of time for YouTube. to receive an extension of time until 30 days after a third amended complaint, especially since no third amended complaint is currently planned and it would delay this action indefinitely. Although counsel for YouTube did call me on the phone, it was at my request to discuss how YouTube could do better with their DMCA and anti-bullying policies. I know I said no reaction, but why would external counsel, I'm serious here, they have their job is defending the lawsuit. They have no say, they have no input. Google's internal policies have nothing to do with their external lawyers. So this is him saying, so yeah, I wanted them to call me about something completely irrelevant to them and wasted their time in doing so. I did not realize we were conferring to minimize motion practice, but parties were unable to find common ground nonetheless. Although plaintiff did not agree to an extension of time to answer, plaintiff also saw no reason that YouTube would need more than 60 days, and none was mentioned by YouTube's counsel. YouTube's counsel also didn't mention that he would be responding to a third amended complaint and his novel interpretation of the motion practice in this action. Instead, YouTube's counsel refused to assist me with getting my DMCA subpoenas processed or to get my DMCA notices properly looked at, but expected me to stipulate to giving them more than the already 60 days that they had to answer. I definitely did not state any intention to wait to file a third amended complaint until after YouTube responded to my second amended complaint. Is that the change? Seriously? Instead of shouting at the court for a whole sentence, bold is shouting, you just shout, did not, and unbolded the rest of that sentence. Yeah. Okay. That looks like the only change, at least that I see. Once again, do it once, do it right. And I mean, if he ever goes to defendants asking for stipulations, if he ever asks them to waive a procedural rule, it's not going to happen. I mean, we're taught in law school, you know, if it's not going to prejudice your client, give the waiver, because the legal community is small, and opposing counsel is going to remember who the jackasses are and act accordingly. So yeah, Mr. Gorman probably never comes across Jose Maria de Castro again. This will be their one and only interaction, this lawsuit. But they got off to quite the start, and just based on this, why would he have any reason to not grant mercy, but to, you know, to cooperate? Because he can be a stickler and go by the exact letter of the rules, and in which case, like I said, say, you know what, the court granted you leave to amend, you supplemented, you need to throw those out. Will the court order it? Probably not, but you know, fuck around and find out. So once again, this one left me more speechless than most. Maybe it's just yesterday we read such a well-written motion that this one just it's at Delete Lawz usual standards, but just by comparison, it was more of a letdown. But with that, thanks for joining me. Once again, I forgot to do this at the beginning. Do all the YouTube things, like, subscribe, share, and I'm sure there's going to be a flurry in the very near future. Hopefully, I'll have something besides this. Yeah, my email's on the on the YouTube page. Send me suggestions for stuff you want me to react to, both legal and finance. So with that, thanks for joining me. I'll see you guys soon. Bye-bye.